Hi, I'm Chip Rogers, and welcome to the AAHOA Educational Experience. Thanks for joining us this week. We are talking about union organizing, and this one sounds like it should be the title of a good book. The Dirty Secrets of Union Organizing is where we're going to start today. And my two esteemed guests are attorneys who specialize in labor law. We'll first start with Sal Sameo with Ford and Harrison. Sal, thank you for being with us. He is out of the great state of New Jersey. And to his right, from the other part of the country, down south, Jacob Monty, who is managing partner with Monty and Ramirez and based in Houston, Texas. Gentlemen, thank you for being with us. Jacob, I want to start with you. Dirty Secrets of Union Organizing. That should get our viewers excited because you're about to give us some things that nobody knows unless you're on the inside.
Well, it's true, and you know the one that we see a lot is the false promise of immigration help, and that's probably the sickest trick we've ever seen, but it's routine. You want help with getting your papers in order, sign the union authorization card, or come down to the union hall. We have good lawyers there that can help you. Look, the fact of the matter is our immigration system is broken. We need comprehensive immigration reform, and there's nothing that can be done in most cases to regularize anyone's status. That's the fact. Organized labor is preying oftentimes on this community and offering them false hope in an effort to try to get their signature on an authorization card. The other lie we hear is that the manager will be fired. Yes, if the union gets in, the manager will be fired, guaranteed. Under our labor law, unions don't have the power to determine who the manager is, only the company does.
Right.
Even if a union wins an election, all they do is get the right to bargain with the owner. So we see that lie often. The other lie is, just outrageous benefits. Oftentimes they'll compare a hotel that's a smaller hotel or a hotel with little services to one of the high-end hotels downtown, and you're clearly not comparing apples to apples. So those are the common lies that we hear in the lodging industry. Again, immigration. We're going to terminate the supervisor, or offering outrageous pay and benefits.
And terminating the supervisor goes back to an interesting topic that you brought up before, that oftentimes what really begins the process of a workforce organizing is not necessarily the wages or even the benefits, but it's the workplace environment that may be specifically tied to an individual, and in this case we'll use the example of we're going to fire the manager or whatever. And so sometimes those promises, as ludicrous as they may sound, if they're tied to an emotional argument, may get people to sign that card.
Absolutely. And when I do training for companies, the supervisors don't like to hear this, because when they hear that a union's at the doorstep, they often say, well, it's because the wages we offer aren't good enough, or if we had a better insurance plan, the union would go away. Many times supervisors don't want to accept the responsibility that if a union is knocking at the door, it's because they haven't been good supervisors. They haven't recognized good performance. They haven't solved problems for employees. Or worse, they've been yellers. They've been screamers. They've threatened employees with termination. They've sexually harassed subordinates. Oftentimes what brings the union to the doorstep is those emotional issues. And that's in the control of the supervisor, not the company.
And again, going back to one of our prior shows, Sal, if the union is over-promising, if they're suggesting, okay, you're making $10 an hour, and if we unionize, you're going to make $20 an hour, that's probably easily put to rest by just giving some facts from the employer. But if it's about the emotion connected to a yeller, that's a lot easier for them to sell.
Yeah, and you hit it right on the head. And with other union tactics that they use, again, is dealing with nonprofits or organizations that seem to be legitimate organizations. Some of them are employer-employee organizations. For example, the Fair Contracting Foundation, where you have large unionized employers and unions working together to eliminate non-union shops, which are smaller employers, so a large employer could get the business. So they'll use these somewhat legitimate organizations, whether it's a nonprofit or it's a union, an employer organization, to back them up, to legitimize their claims. Another thing they'll do is complain to the government. Now, if you complain to the government and you're a union, it's going to cause an investigation. So first they'll go out and they'll say, look, they're not paying you correctly. And then they'll go to the DOL and get the DOL to start an investigation. And they'll say, see, we told you they weren't paying you correctly. Now the DOL is here. We can help you. And then what they'll do is they'll have a plaintiff's attorney come in and they'll file some sort of action, class action. Once they file the action, part of the fear employees have is of retaliation. So they'll file a class action and all of a sudden nobody's retaliated against, and they assume that the person that's filing the class action is going to get fired. Well, they don't. And it gives them the encouragement to, come and really give credibility to what the union's saying. And then that's really where the puffery starts, and they start saying anything to get the people to join in.
Chip, it's all about creating a villain, like Sal said. Yeah. And if the employer's not acting like a villain, well, you got to create the villain by calling OSHA, by calling Department of Labor, by filing a few EEOC charges, all of that to hurt the brand, to hurt the property. And then the union emerges as the shining white knight in shining armor to solve all of the problems.
Tell me about these empty promises, some of the lies that are used to get cards signed. And the one I'm really interested in is using credit unions to promise loans. I mean, at a time when so many people need access to cash.
Well, Sal alluded to it. A third party, a nonprofit that appears unaffiliated but is really there to push the union agenda. We've seen this in California where the credit union emerges all of a sudden and offers help on refinancing. Who doesn't need help on refinancing? I do. Who wouldn't want a lower rate? So they bring them in under the guise of trying to get them lower financing, and then they ask them the questions. How does your supervisor treat you? How much are you earning? And we see that a lot. We know that in California as well, the Mexican consulates have unknowingly been involved in some of these efforts where they'll actually have fairs on credit counseling, and all of a sudden the discussion goes to unions. So you have to be aware of that, and you have to know that underhanded tactics are sometimes used. The best defense toward combating unions, though, are good supervisors that are trained and know how to treat their employees, and also supervisors that know how to spot the warning signs. We've heard of, the dashboard. Well, there's some signs out there that your supervisors need to know. If they see them, that means danger and union activity is at the workplace.
All right, two key words here that you have written down: dignity and respect. Everybody wants to have dignity and be respected, but I think this plays back into the idea of having a good manager and the emotional tie or the emotional play that the union's going to make to try to attract somebody.
Right, and you see it a lot with the non-profits. I mean, here in New York, it's actually a good organization, but Make the Road by Walking is a prime example. They're a good organization. They work hand in hand with the union, but their main goal is unionizing employees. And they'll go to churches, they'll work with churches, and institutions, especially immigrant workforces, tend not to trust the government or government officials, but they do tend to gravitate towards places of worship and trust the people that go there. So these type of organizations will go there and give speeches to their people about their rights and everything else, and really try to get people rallied up. Another method that I've seen used is where you find a leader in the community within the workforce who's also a leader, and you give him a job. You make him part of this organization, or you make him an agent of the union, and that helps bolster the credibility of the organization. In terms of the own managers, you really should know what your employees are doing. I'm a big advocate of giving the 800 anonymous helpline or ethics line. Let employees know that if they have a problem, they don't feel comfortable going to their manager, there's an 800 number they can call, and nothing's going to happen to them. That's important. Creating a culture of compliance is important. Another thing is, check Facebook. I mean, check Facebook, check these social media sites and see what your employees are saying about your company. It's pretty amazing to me when you go onto these websites and you see what people say about their employers. So sometimes it's very positive, sometimes it's very negative. But as an employer, you should know what the climate is in your workforce. And if you have a disgruntled workforce, figure out why before a union comes in.
10 years ago, if you wanted to know what was going on at the workplace, you went and looked at the bathroom graffiti, and that told you. Now, and it was true. John's a jerk.
Right.
John was the boss who would yell all the time, and now it's social media. Yeah, absolutely.
So social media is the bathroom wall.
Yeah, in many cases, I think.
Depending on who's writing it, yeah.
All right, we're out of time for this segment, but we've got another very informative segment coming up. My guest, Jacob Monti and Sal Sameo. Gentlemen, thank you for being with us.
My pleasure.
We'll be back coming up right after this. Welcome back to the AAHOA Educational Experience. I'm Chip Rogers. My guests this week include Sal Sameo from Ford and Harrison and Jacob Monti, Managing Partner at Monti and Ramirez, two very good labor attorneys. Gentlemen, thank you for being with us. Sometimes the term labor attorney sounds boring, but you guys have been fantastic, giving us a lot of good information. We have talked so much about the Department of Labor, audits, of course, unions. Before we finish up the show, I want to talk about immigration compliance and really how there actually may be a link between Department of Labor audits and immigration compliance and making sure that you're covered in both areas.
Well, first let me say we are seeing compliance initiatives by ICE like we never have before.
Just so people know, ICE is Immigration and
Customs Enforcement. We are seeing companies having to offer their I-9s for inspection. ICE is routinely examining I-9s now, and the fines that employers are facing are substantial. In addition, some employers are facing criminal charges, all because they didn't get the I-9 right, or they took the I-9. The I-9 is the form that's required for all employees, and there's no small employer exception. If you have one employee, you must have an I-9 on him. But all of this is because employers have not understood the importance of the I-9 and what it means to have it completed properly, to make copies of documents. If they choose to make copies, they have to keep the copies with the I-9. But this is the one area where employers need a lot of education.
All right, so Sal, tell us about Department of Labor comes in to do an audit.
Right. So the DOL is going to focus, they're going to check your I-9s, but they have a memorandum of understanding with the INS or ICE. They will provide information about employers who are not in compliance, either with I-9s or EVerify, and go after the employers. However, they will not go after the employees and try to deport employees who are undocumented. In fact, there's a Supreme Court case that says that if a employee is undocumented, you can't bring up their documentation status during any sort of wage hour or Department of Labor or private lawsuit dealing with wage hour law. I've been involved with cases when I was at DOL where defense attorneys tried to bring up the employees' status, whether or not they were legal or illegal in this country, as a way of intimidating the employee or saying that's why we paid them in cash. And the judge had found that that was per se retaliation. Just bringing up their status during a deposition or questioning was per se retaliation against the employee. So it's very one-sided. It's, go after employers, but not the employees. So it's, at least in DOL investigations.
That's very true, and a lot of employers don't understand that. They think, well, the person might be undocumented. They're not going to go to Department of Labor, or they're not going to find a plaintiff's lawyer willing to file the lawsuit. That's not true. You can be undocumented and go to Department of Labor. You can be undocumented and go to a plaintiff's lawyer and sue for overtime. So, that is that you're undocumented doesn't mean you can't go and complain against the employer.
You mentioned EVerify, and of course this is kind of, in a sense, you'd almost characterize it as somewhat of an electronic version of an I-9 form. But what is the requirements if you're using EVerify? Are you still required to fill out I-9 forms?
Absolutely, Chip. EVerify is now, it's still optional for most employers, but certain states have required it. States like Arizona and Georgia. And Alabama has required it as well. So now we have a program that is optional for some employers but mandatory for others. And basically, if you have to do the I-9 as well, though. You can't opt out of the I-9 even if you do EVerify. EVerify is just an electronic database that verifies the employee and their eligibility to work in the U.S.
Fraudulent documents, that is obviously a big issue. If you're an employer and I walk into your office and I present you I'm obviously a white male, 6'3", 190 pounds. If I walk in and show you an ID that shows I'm an African-American female, 5'8", what is my responsibility as an employer for accepting that type of document?
Well, obviously, you don't look like a female. So the person who completes the I-9 could not complete the I-9 if that's the documentation they presented. So you have to be able to take the I-9 obligation seriously, but at the same time, you can't get carried away. If you're an employer and you doubt that someone is really documented and you say, no way, Chip, this ain't your documentation, you run the risk of a discrimination lawsuit, because we have the Office of Special Counsel that exists, that's part of Department of Justice, that goes after employers for asking for too much documentation.
So the poor employer is stuck with, you need to verify, and just by looking at them at least, whether the person matches the document, but you can't go too far in asking questions because that may be discrimination.
Absolutely. There's a big catch-22 there, and we represent a lot of employers that are facing charges by the Office of Special Counsel right now.
All right, we have talked about this on prior shows, but I don't think it's too much to overemphasize it, and that is no match letters. So the Internal Revenue Service or Social Security Department would send you a no match letter. Explain what that means.
Yeah, we're starting to see no match letters being issued again now. Basically, it's a notice from the Social Security Administration saying, hey, this number doesn't correspond with this name. And the Social Security Administration also tells you that you're not supposed to terminate the employee that is the subject of the notice. They're just telling you this could be an indication that they are undocumented, but don't terminate the employee. What you're supposed to do is give the employee a period of time to resolve the mismatch. Some mismatches or no matches are the result of a typographical error, or maybe with Hispanic employees, they have the mom's last name inverted for the dad's last name. So there can be legitimate reasons for a no match. You have to give the employee an opportunity to correct that, and if they're unable to correct it, then perhaps termination may be in order, but you don't go out and terminate them immediately. And you should just give them an opportunity. Typically it's 60 days to correct the problem if it's correctable, and that complies with your obligations under the no match notice.
And Sal had spoken earlier about, at least with the Department of Labor, how the policies under the Clinton administration, the Bush administration were very similar. The Obama administration had changed pretty significantly. Are we seeing that? Because I'm hearing that at least the immigration enforcement policies of the Bush administration to the Obama administration are starkly different.
Starkly different. You know, under the Bush administration, we really never saw I-9 audits. We had a few high-profile raids in the meat industry, but we are seeing I-9 audits like we've never seen them before, and we're seeing what's been referred to as silent raids. What ICE will do is they'll come in, review the I-9s, and then tell the employer, you must terminate these employees. So that's why we have the term silent raid. There's no bus that shows up, there's no helicopter, but the end result is the same. The employees are required to be terminated. So they lose their job, the employer is out of workers, and these silent raids are happening all over the country right now.
We have less than a minute to go. What, if I'm an employer, large workforce, what is the single best thing I can do to protect myself from any type of immigration compliance issue?
Get the I-9 right, review the I-9, do a self-audit on the I-9. If you need to bring a lawyer or outside consultant to look at your I-9s, if they're not right, correct them. The I-9 doesn't have to be perfect, but you do have an opportunity to review it and get it right before immigration comes calling for it.
And if I could just add one thing, I know a lot of employers try to get around the I-9 by hiring people as independent contractors. We talked about the perils of that before. That is a mistake. Don't try to get around I-9 laws by making someone an independent contractor, because you're opening up Pandora's box for a whole other area of liabilities.
It could be very costly.
Very, very costly.
All right, so for Jacob Monty with Monty and Ramirez, thank you so much for being here, and Sal Sameo with Ford and Harrison, we really enjoyed it. I'm Chip Rogers, and if you'd like to contact me, you can do so via email. We can talk about any of these issues, and of course I can always forward your name and your email address to one of our fine attorneys. Chip at AAHOA.com. It's Chip at AAHOA.com. Thank you so much for watching, and we'll see you again next week.